And good afternoon, and welcome back inside the law. I'm your host, Philip Holloway. Let me start by saying welcome to everyone who's here. I'm seeing already in the comments that we have people from all corners of the United States, and I'm so happy to see it because it's 4:15, 4:17 here in the Eastern time zone, and where you are, it might be in the middle of your workday. So I appreciate you taking the time out to be here. I know that sometimes we talk about different topics. One of the favorite things that we always come back to is of course Fulton County District Attorney Fani Willis. And while this show is not meant to be just about Fani Willis, this show is about the justice system and things that are currently in the news today. Now, of course, across the United States, we have all sorts of things. We've got the Donald Trump trial that's going on in Manhattan, of course, and we've talked about that here inside the law, and we'll continue to do so. And of course, we have the protests and the not so peaceful protests that are popping up at various colleges and universities across the United States. We have arrests that have been taking place, of course, in Manhattan, UCLA, other things. We've talked about those, and we will continue to do that as well. But sometimes things come up that offer me an opportunity to take you inside the law to places and to explore things that we've not exactly explored. Now, while Fani Willis is no stranger to the subject matter of this channel, we haven't talked a lot about civil litigation in here. And so today we have an opportunity to learn something and to explore something of civil litigation, and in the context of someone that we know all too well, which is, of course, the Fulton County District Attorney, Fani Willis. Now that we have, I think, 212 or so on people in here, I want to go ahead and start by showing you a quick video, and that should get us going with our subject matter today, because Fani Willis has been sued by a Georgia State Representative named Mesha Mainor. And one of the things that Representative Mainor is accusing the district attorney of is a civil violation of Georgia's racketeering law. That's right. Fani Willis herself has been hit with RICO allegations.
Chesley, thank you. A news conference is happening right now where State Representative Mesha Mainor is announcing a lawsuit against Fulton County District Attorney Fani Willis.
11 Alive's Ariana Manish joining us live from the Capitol. Ariana, tell us why this lawsuit is being filed.
Well, Aisha, this press conference, it just wrapped up. Representative Mesha Mainor, she is suing DA Fani Willis, Fulton County Commissioner Marvin Arrington, as well as the Fulton County Board of Ethics. Now, the representative, she's claiming that she's a victim of a years-long criminal stalking case. She's alleging that DA Fani Willis failed to prosecute properly her alleged stalker. Now, she's claiming the stalker was a former campaign volunteer. Now, she says that the DA allowed this former stalker, this alleged stalker, to be released on bond for non-bondable crimes and didn't contact witnesses that she provided. She wanted the DA to properly investigate this case, and she says that the DA failed to do so. She also claims that Marvin Arrington mishandled the prosecution of this case, as well as he was representing the alleged stalker. She was also joined by victims that one father says that his son had been held in Fulton County Jail for over 90 days, and she's saying that these people, they're all victims. They share the same stories of mishandling by the DA's office. Take a listen.
Accountability is paramount, especially with the Fulton County DA failing to assist citizens affected by domestic violence, stalking, or unjust incarceration. The connection is victims. This today is about victims. And DA Fani Willis is the chief court officer from the state in Fulton County. She directly impacts what is happening in the jail.
Now, she says she wants the DA to admit her missteps in prosecuting her case. She says she also wants a jury trial against Willis, Arrington, and the Board of Ethics. Now, when asked the legal status of her case, she refused to answer. She's also calling on people who feel that they were victimized by DA Fani Willis's office for them failing or slowly acting on their case to reach out to their office. Reporting live from the state capitol, I'm Ariana Maniz for 11 Alive. Back to you.
Ariana, thank you. Definitely one we will stay on top of.
All right. So there you have the setup. That's an excerpt from a recent press conference that Representative Mainor gave. And that sort of sets it up. But before we get into the actual lawsuit itself, I've got a little bit more information for you. That's what we're all about here, is we're about information. And here you go. Under Georgia law, Georgia has a law. It's called the Crime Victims Bill of Rights. Many states, if not most, have something similar. It's also known as Marsy's Law. These rights are constitutionally protected, and they are also enshrined in Georgia's Constitution. But these rights include the right to reasonable, accurate, and timely notice of any scheduled court proceeding or changes to such proceedings, the right to accurate, reasonable, and timely notice of arrest, release, or escape of the accused, the right not to be excluded from any scheduled court proceedings, the right to be heard, that means to speak at any scheduled court proceeding which involves the release, a plea, or the sentencing of the accused, the right to file a written objection in any parole proceeding, the right to confer with the prosecuting attorney in any criminal prosecution related to the victim. Let me read that again. The right to confer with the prosecuting attorney in any criminal prosecution related to the victim. The right to restitution as provided by law, the right to proceedings that are free from unreasonable delay, and the right to be treated fairly and with dignity by all criminal justice agencies involved in the case, and the right to file a motion in the criminal case within 20 days of a court proceeding requesting to be heard if the victim has properly requested notification and is not given notice of a court proceeding. And the list of crimes that this specifically applies to is very long, but at the very bottom of the graphic on the screen, you'll see that it includes the offense of stalking and aggravated stalking. Now, under Georgia law, there are two types of stalking. There's misdemeanor stalking, which carries up to 12 months in jail and $1,000 fine. And then there's the felony version of aggravated stalking. Now, aggravated stalking is the bad one. This is the one that when somebody violates a temporary protective order, or perhaps they violate a conditions of bond, some court order to stay away from somebody. And if they violate that court order, they can be subject to felony criminal charges for aggravated stalking, where they are frequently held without bail, because these are the charges that normally make prosecutors and judges really, really nervous, because what they're afraid of is if they let somebody out of jail and they're, a stalker, like a really dangerous kind of stalker, and then heaven forbid something terrible happens, then the judge is going to be the one, or the prosecutor is going to be the one with the news camera stuck in their face saying, why did you do this? Why did you let him out? Or at least that's what they're frequently concerned with. And that makes sense. I completely understand that. Now, I can also tell you that there are some people that are accused of maybe the felony version of this charge, that really the misdemeanor might be a better fit. But in any event, that's not really here nor there for purposes of our discussion today, because today we're going to be getting into what State Representative Mesha Mainor says was her experience. But before we do that, I see we have 500 people in here now. Thank you all very much. Please go ahead and hit that like button. I see we already have some gifted memberships for Inside the Law. Thank you all very much for that. Those are the kinds of things that help support this channel and allow us to bring you additional content like this. Now, there's another defendant here. You've seen him in this channel before here Inside the Law. And for those of you who don't remember who Fulton County Commissioner Marvin Arrington Jr. is, let me refresh your memory.
We got a signed letter of intent. Shut up.
Just come on. Just a minute.
Shut up. I'm talking.
Just a minute.
You're not talking to me.
Shut
You're
up.
not talking to me.
Shut up. I'm talking.
Make me.
I'm talking.
Make me.
I'm talking.
Make me.
It's my time.
Make
It's
me.
my time.
Make me shut up.
It's my time.
I didn't think so.
Yeah.
Is that off?
No,
You may remember we showed that clip in another live stream regarding the Fulton County follies, where we talked about the dysfunction that exists in Fulton County government, and that it starts at the top, and that's with the Fulton County Commission. And that's just one example, and it happens to be one that I've used before, and I thought maybe you would remember it. If you don't, and if you didn't see that particular live stream, go check it out. It's very well worth the watch. All right, so that's Commissioner Marvin Arrington Jr. His father, by the way, has passed away now. He was a longtime Superior Court judge on the bench in Fulton Superior Court. All right, so let's get to the lawsuit against Fani Willis. Here you have the pleading. And by the way, I have it on good authority that there may be soon to follow a revised or amended version of this, but I can't imagine that the factual allegations will change much. So we can get right into it. We got at the top, we've got Mesha Mainor is the plaintiff. She's suing Fulton County itself, the ethics board, the district attorney's office, and I've got highlighted what I think are the most important part. Marvin Arrington, individually and in his official capacity as Fulton County Commissioner. So when you have an elected official, if they are sued for things that they do pursuant to their job, they generally are sued in their official capacity. Here you have the Commissioner Arrington sued both ways. He's sued as an individual human person as well as in his official capacity. Same thing for Fani Willis. She's being sued individually and in her official capacity as Fulton County District Attorney, which is certainly interesting, but we'll come back to that. The very beginning of the complaint comes now Mesha Mainor, plaintiff. By the way, I don't know why we have to write this way. Who goes around talking this way? Comes now John Doe and says this, that, and the other thing. Just why can't we just say the plaintiff hereby sues the defendant for the following reasons? But nevertheless, lawyers like to use fancy language, but when you see that, that's what it means. That's just the beginning of the complaint. She's suing under 42 United States Code Section 1983. Now, this is a federal statute, but she's suing in the Fulton County state courts, which you can do under this particular law. But this tells me that this is an allegation that these government officials have violated the civil rights of the plaintiff, as alleged. So this is a federal civil rights statute. This is the same law that typically you would, if you or somebody is a victim of, say, police brutality or unnecessary use of force, this is the kind of action that you would bring. You would bring it under the same federal law, Section 1983 of 42 USC. All right. So here you go, defendant Fani Willis and the statement of the facts. Plaintiff Mainor is a state representative for the Georgia House of Representatives in 2009. And normally, by the way, that wouldn't be the kind of thing that you would necessarily put into a pleading, but it's relevant for the reasons that we'll get to. Her being a state representative is really is part and parcel of what happened to her. In 2019, plaintiff ran a campaign for the elected seats, which she now holds. Mainor hired Mr. Corwin Monson as a campaign volunteer. And by the way, if you've ever heard of Representative Mainor, she made news some time ago, and I suspect that it had to do with this. She was a Democrat, and she switched parties to the Republican Party, and it had to do, as I understand it, with issues related to the Democrat Party in Georgia having some objections to what the legislature was doing and creating an oversight body, a state agency that would was meant to oversee prosecutors. Okay. So she split with her party. She became a Republican. I suspect it might have something to do with this. And if I can get her on the show, and I'm efforting to do that, hopefully in the very near future, we can talk to her about that. All right. So she had this Corwin Monson as a campaign volunteer, she says. Plaintiff Mainor and Monson were associates for several years and had many friends in common. Monson assured Mainor that he could help her get elected to this position. And in February of 2019, Mainor was forced, she says, to terminate Monson from his volunteer position after witnessing his unruly, belligerent behavior. What specifically that was, I don't know, but I want to ask her. So if we can get her on here, I'm going to ask her if she can elaborate on exactly what that was. But in any event, she claims that Monson began to stalk her after she fired him. According to this lawsuit, Monson would show up uninvited at campaign events. He joined the plaintiff's church, and he even would sit outside of her home. It's enough to unnerve anyone. Mainor, Monson called Mainor from several different phone numbers and left her several voicemails. Monson later turned those voicemails into a song. Can you imagine? Anyway, Monson admitted he was in love with Mainor, and he even showed up at her home once and proposed to her in front of her minor children. This is all the allegations made in this lawsuit by Mainor against Fulton DA Willis and others, including Commissioner Arrington. She goes on to allege that they had never had a romantic relationship. And in June of 2019, Monson was cited for criminal trespass, which is a crime, after coming to her home and refusing to leave her property. Mainor filed a temporary protective order against Mr. Monson, and a judge granted that TPO against Mr. Monson. Now, the way it works in Georgia, if you think you're being stalked or you're afraid of somebody, you can go get what's called an ex parte. Means one-sided. The plaintiff goes and sees a judge. They have a hearing and nobody else is really there. And if the judge believes there's enough evidence, the judge will issue it on a temporary basis, and it's good for 30 days. And after 30 days or so, there's a hearing scheduled where the other side gets to come and they get to present their case if they have it. And then the judge decides whether to make it a more permanent or what we call a 12-month order. So she's saying here that the judge granted the TPO, and in September of 2019 and again in September of 2020, Monson was arrested for violating the TPO. Now, so let's think about what's going on in September of 2020. This is sort of when the race for the district attorney's office was really heating up. You had Fani Willis in a runoff with Paul Howard, the former district attorney. And so, and of course, September 2020, it doesn't say what month, but of course, we're getting close to the general election, which of course is early November. So we're in the election season here. So keep that in mind because it's relevant for context. So it says in September of 2020, the Fulton DA's office indicted Mr. Monson for aggravated stalking and for violating the TPO. So aggravated stalking being a felony, violation of a TPO is a misdemeanor. Sometimes those two charges go hand in hand. But the DA's office at that time, of course, was run by the former district attorney, Paul Howard. Fast forward to January of 2021. This is during the Fani Willis administration. The DA's office indicted Mr. Monson for a second aggravated assault charge, of which plaintiff Mainor was the victim. Now, aggravated assault is Georgia's version of attempted murder. And, if it's aggravated assault, then that would be an assault with a deadly weapon. It would be assault with intent to rape, rob, or kill, something along those lines. But in any event, there you have it, additional felony charges in January 2021. Mr. Monson, she says, is a close friend and associate of the defendant, Commissioner Arrington. So I noticed that we have twice as many people as we did in here a few minutes ago. Let me reintroduce those of you who weren't here. This is Commissioner Arrington.
We got a signed letter of intent. Shut up.
Just come on. Just a minute.
Shut up. I'm talking.
Just a minute.
You're
I'm
not talking to me.
Shut
You're
up.
not talking to me.
Shut up. I'm talking.
Make me.
I'm talking.
Make me.
I'm talking.
Make
It's
me.
my
Just a
time.
minute.
Make
It's
me.
my time.
Make me shut up.
It's my time.
I didn't think so.
Yeah.
Is that off?
No,
All right. So this is Commissioner Arrington. So you've got him on the Board of Commissioners, and for the reasons that we're about to get into, his membership on that body is very, very relevant. All right. So let's get back to allegation 24. Monson is a close friend and associate of defendant Commissioner Arrington. Monson hired defendant Commissioner Arrington as his defense attorney in the September 2020 aggravated stalking case. So he's also a practicing attorney, as was his father, who of course was a now deceased, but a retired Superior Court judge. So now we get into what they are calling defendant Commissioner Arrington's influence. An assistant district attorney on Mr. Monson's case informed Mainor of the influence defendant Commissioner Arrington wielded in the DA's office. Now, think about this. What kind of influence might a county commissioner have in the district attorney's office? Well, let's see. Arrington used his influence to circumvent the office policies of the district attorney's office, including intimidating assistant DAs by copying the district attorney on emails. That's their boss. He's putting their boss on emails. When a lawyer is negotiating or talking about a case with, opposing counsel, it's usually with an assistant prosecutor. It's not the boss. But here you have, now look, that doesn't mean it can't be done. And I've done it myself. Sometimes you do get the boss involved, but it's not like you're going over somebody's head necessarily. They're just part of the conversation. But what they're alleging here is that he is intimidating assistant DAs by copying the district attorney on emails, negotiating plea deals directly with the district attorney instead of the assistant DAs, and demanding meetings with the district attorney when assistant DAs refused to bend to his will. That's allegation number 27 made by State Representative Mainor. Fulton County residents, she says, hire Commissioner Arrington as a defense attorney because of the power he is able to yield in the DA's office. Here we go. We're getting into what kind of power that might be. As she says in item 29, as a Fulton County Commissioner, defendant Arrington is responsible for managing, setting, and releasing the budget for the Fulton County District Attorney's Office. So Arrington is one of the people on the Board of Commissioners that provides money in the budget for the DA's office. We know what Fulton County DA's office likes to do with its money. But anyway, on July 14th, 2021, DA Willis went before the Board of Commissioners, including Arrington, to request more money from Fulton County to hire more staff. During that meeting, Arrington passionately advocated, and we've seen an example just now of him passionately advocating, right? But he passionately advocated for money to be released to the DA's office. At one point during the meeting, Arrington states, "Fuck the lowest millage rate. I don't give a darn about the lowest millage rate. Where's the money the DA's office needs?" So think about this. You got him on the one hand, she's going to him asking for more money. Well, him and the rest of the board asking for more money for her budget. This is in July 2021. She's gearing up for certain high profile cases that we've talked about. So she's asking for more money. And she's going to this man who also wears another hat. And the other hat that he wears is as a defense lawyer trying to get somebody a good deal who Willis's office is prosecuting. Okay. Does anybody can anybody see an argument there for this, where this could possibly be argued to be a conflict of interest of some sort? Anyway, defendant Commissioner Arrington, she says, is also responsible for managing, setting, and releasing the budget for Fulton County judges. The judges too. All right. The judges have a role in how criminal cases are resolved. And she says that says also Arrington has these duties. He also serves as a defense attorney for criminal defendants within Fulton County. Okay. 33 says that when he's wearing that hat, he is paid by criminal defendants for their defense. From November 2020, that's the election, through October 2021, defendant Commissioner Arrington unduly influenced the criminal proceedings of both the aggravated stalking cases on behalf of Mr. Monson in the following ways. Arrington used his influence to broker a plea deal with then Fulton County DA Paul Howard. She goes on to say the plea deal that Commissioner Arrington negotiated with Mr. Howard, that's the predecessor of Fani Willis, was not presented to the opposing counsel, which they say is the assistant district attorney. Well, to that point, look, I think that the district attorney is always the opposing counsel. The assistant DAs are always technically like co-counsel because they act with the power that's given to them by the DA. So I don't necessarily see it that way. I think the opposing counsel is the elected DA, and in addition to the assistant DA. But in any event, they go on to say the plea deal would have allowed Mr. Monson to plead guilty to a misdemeanor, although he was charged with a violent felony. The reference plea deal contravened DA's office policies. Specifically, the DA's office policy was to only offer misdemeanor pleas in place of felonies, only in extraordinary circumstances. They go on to say the DA's office policy was to punish repeat violent criminal offenders to the full extent of the law. Furthermore, one of the DA's office policy goals was to lower the occurrence of domestic violence against women in Fulton County, Georgia. She says Mr. Monson has a prior criminal history, including a prior aggravated assault, which was reduced to a misdemeanor and a negotiated plea. All right. And we're going to talk more about the facts of the case. But just before we do that, I want to check in here on the chat. We've got 1,000 people in here. Welcome to everybody here. Thank you so much for being here. This channel is now over 26,000 subscribers. For those of you who haven't subscribed, please hit the like button, but also subscribe and make sure you tell your friends and your neighbors, anybody you can think of, to subscribe, because the next goal is for 30,000 subscribers. And by the way, I see that we have some folks with the super chats. Thank you very much for the super chats. Thank you for those of you who have also joined the channel, and some of the memberships that have been, I guess, gifted this afternoon. Thank you very much. I'm very humbled and blessed. And if you want to support the channel, there are links in the video descriptions with some additional links for ways to support the channel so that we can continue to bring you this great content. But thank you all very much for all of the support. Make sure you hit that like button. I see some of the comments, like Melanie. If you haven't done that, do that. There's lots of information out there. My point here is not to beat up on anybody. I'm simply talking about the allegations made in this lawsuit. But you can certainly check out some things for yourself. One thing that you will, I think, find out if you do a Google search, you'll see that there are some news items out there related to efforts by Arrington and others to essentially do away with the Fulton County Board of Ethics. And we're going to talk more about that when we resume talking about this lawsuit. But thank you all to everyone who's here. Please hit that like button. All right. Jennifer says, thanks for your hard work. Jennifer, thank you for being here. I appreciate the kind words. All right. So let's get back into this. All right, here we go. Back into the lawsuit. 36, Commissioner Arrington is heard on, listen to this, guys. This is incredible. This is, when I read this earlier, I just couldn't believe it. Arrington is heard on jail calls with Mr. Monson, conspiring to cause the sitting judge on the criminal case, Judge Kelly Lee Ellerby, to be removed. Now, first off, all right, so why is a criminal, we know, lawyers know that the jail calls are always recorded, always. And in fact, the people that are in jail know they're recorded. There's a big sign that says your calls are being recorded. Lawyers shouldn't be talking to clients on a recorded call because, first off, it's just stupid, but it destroys attorney-client privilege. There is no privilege when you're talking on a recorded line or in the presence of a third party. So why somebody is having attorney-client phone calls on a recorded line, I do not know. But Representative Mainor, maybe she'll explain that. Hopefully we can get her on the show to talk about it. But in any event, I'm sure she and her lawyers are glad to have this evidence because, according to her, on these recorded jail calls, Arrington encouraged Mr. Monson to file a fraudulent complaint against Judge Ellerby. Ellerby, it says, according to Arrington, Ellerby needed to be removed from Monson's case because it was likely she would reject the misdemeanor plea he had negotiated with Paul Howard. Now, to that point, what you need to understand, and this is why we go through this, and I take the time to explain it, because a lot of people don't realize that if you have a plea deal with the prosecutor, that's great, but it doesn't mean a damn thing unless or until you get the judge to sign off on it. The judge always is the final say on whether a plea deal goes through or not, always. And if you can't get it past the judge, then it doesn't happen. We've all been there. We've all had negotiated plea deals that occasionally a judge will reject. It doesn't happen a lot, but it happens frequently enough that lawyers and prosecutors have to keep that in mind. When we negotiate a plea deal, we want to make sure we know our judge and we craft a resolution that we believe, based on what we know about the judge, we believe the judge will say, okay. Otherwise, you got to go back to the drawing board. So hopefully, if you reach a plea deal in a criminal case, both sides want the deal to go through. All right. So apparently, according to this lawsuit, based on jail calls that are recorded between lawyer and client, there's a concern that Judge Ellerby might reject the plea deal. And according to the lawsuit, Arrington apparently is heard on this audio recorded jail call saying the problem is the fucking judge, in reference to Judge Ellerby. All right. Anyway, well, that's certainly something that's very remarkable. After filing a fraudulent complaint against Judge Kelly Ellerby, Mr. Monson temporarily had criminal proceedings held before different judges, including Judge Adams. Okay. Now, Judge Adams, in my experience, is sort of a no-nonsense judge, and she doesn't put up with a lot of nonsense off people. But it says here, on information and belief, defendant Commissioner Arrington has a personal relationship with Judge Adams. Remember the earlier allegation here that the Fulton County Board of Commissioners not only controls the budget for the district attorney, but also for the judges. Bear that in mind. Prior assistant DAs on Monson's case, back up. I skipped ahead of myself. It says on information and belief. And by the way, this is another thing. When you hear lawyers using that language, what we're saying is that we have reason to believe. This lawyer is stating that there's a good faith basis, according to the lawyer at least, for stating that defendant Commissioner Arrington used his influence to have ex parte meetings with Judge Adams. Now, what ex parte is Latin, and what that means, it means one-sided. And why that's important, well, first off, it's unethical. But if you're a party to a case, whether it's a criminal case or a civil case, you can't just go talk to the judge about the case without the other side. You've got to have all parties present, even if it's in chambers or if it's on the phone or if it's on an email. The law says you can do ex parte discussions about scheduling. Judge, will you please schedule our plea for such and such date? You can do that kind of thing, but you can't have substantive conversations about a case without the other side participating. It's called ex parte. It's It's unethical. Judges have been removed from the bench for it. Lawyers and other have been, sanctioned for it. It's just something that we don't do. It's like lawyer 101. Don't have ex parte discussions with the judges. And it's being a judge 101. Don't let people have an ex parte conversation with you. Okay, so goes on to say prior assistant district attorneys on Monson's case informed the plaintiff that Judge Adams' engagement with Monson and Arrington during a hearing was unlike her typical behavior, as she was deferential to them and allowed outbursts from them both. Now, I find it very, very hard to believe that that Arrington would engage in any kind of an outburst.
We got a signed letter of intent. Shut up.
Just come on, just a minute.
Shut up. I'm talking.
Anyway, apparently, according to this lawsuit, this judge tolerated outbursts. All right. Third, on jail calls between Arrington and Monson, Arrington agrees to use his influence to get Monson a favorable outcome. Arrington states he will use his father, Marvin Arrington Sr., a former Fulton County Superior Court judge, father's influence to sway the proceedings. Arrington insinuates that his position as commissioner will result in a favorable result for Mr. Monson. Fourth, during jail calls, Arrington admits to telling Fani Willis, who was then the DA-elect. So this would have been after November 2020 and prior to January 1st, 2021. So she was district attorney-elect. During jail calls, Commissioner Arrington admits to telling Fani Willis, who was the DA-elect at the time, about the case with Mr. Monson in advance of her being sworn in. And the commissioner states he wants Miss Willis to know that, quote, that bitch is crazy, which is a reference to plaintiff State Representative Mesha Mainor. I've talked to her. I know people that know her, and she's not crazy. She's very, very, very nice lady. Nevertheless, that was what the allegations are. Therefore, it says Commissioner Arrington used his influence to bias Miss Willis against plaintiff Mainor. During these same jail calls, she goes on to allege Commissioner Arrington encouraged Monson's wife. Now, I thought Monson was proposing marriage to Mainor, but apparently he's married, because the allegations are Arrington encouraged Monson's wife to harass Mainor. Plaintiff Mainor later sought a protective order against Ms. Monson. All right. After the referenced jail calls were publicly released in December 2020. So maybe we can track down some of those and listen to those here inside the law. I would love to hear those jail calls. Defendant Commissioner Arrington resigned as Monson's attorney. Well, that's understandable. If these jail calls say what they're said to have said, and if they were released publicly, I understand why he would withdraw as counsel. In January 2021, the claim says, District Attorney Madam Fani Willis. Now, before I go any further, this reference to Madam Fani Willis, this is what she's referred to around the office, I'm told. And I'm told that, and I don't know this for a fact, but I'm told that it's commonplace that that's kind of what she expects. And I've seen it in other places. So it's interesting that we see that in this lawsuit. She's referred to as Madam Fani Willis, was sworn in as the Fulton County District Attorney. As the top prosecuting official in Fulton County, DA Willis became responsible for the adjudication of Monson's criminal case. Now, here we get into the heat of the meat of the matter, I should say, with regard to Willis. Willis drops the ball, negotiated plea for Monson. Says, although Arrington stepped down as Monson's criminal attorney, he continued to wield influence over the criminal case. Namely, he maintained that Paul Howard had offered a plea deal consisting of the alleged felony being reduced to a misdemeanor. Goes on to say that although Monson was ultimately not offered that misdemeanor plea deal, Willis did dismiss one of the aggravated stalking cases, and on the remaining aggravated stalking case, DA Willis offered Monson a plea deal of 3 years to serve 1 in prison. Now, granted, he's already in jail. He's apparently in jail because that's how we have the jail calls, with the balance on probation and credit for the time he had already served. Plaintiff Mainor was not informed of the plea deal to the extent, Plaintiff Mainor was not informed of the plea deal extended to Monson prior to him accepting, which is a violation of the Crime Victims Bill of Rights, Marcy's Law. That's what we went over at the very beginning. The Crime Victim Bill of Rights, which provides that individuals who are victims of crimes have specific rights in the process. It says Mainor did not approve of the negotiated plea deal extended to Mr. Monson. And I can tell you from my own experience, in these kind of cases, what judges are going to look for typically, maybe they let somebody out of jail, but they're going to have them on probation for an extended period of time because they want to have leverage to control people's behavior. If they're on probation and they violate probation, you can do something about it. But if you give them a short period of time on probation and they violate the terms, or they contact the victim again, something like that, or God forbid they hurt the victim, then you're not able to do a probation revocation. And so the idea is that most judges, it seems, will want to have people on probation for a longer period of time on these stalking cases, because normally judges are very, very concerned about what could potentially happen if things go south. All right. So Monson's plea deal, she says, was not appropriate according to Ms. Willis's own interoffice policies or her stated priority of protecting women. Ms. Willis, by her own words, created the, quote, first domestic violence unit in Fulton County. She goes on to allege that Monson's shortened probated sentence was not consistent with the office's policy of recommending a larger probation sentence to men convicted of domestic violence in an effort to protect women longer. Willis and the DA's office failed to properly investigate it. Listen to this, guys. According to this, the allegation is that the DA's office failed to interview a single person who had witnessed Monson's behavior towards Mainor. Now, I'm just thinking here out loud, maybe if somebody had done an interview, they would have known things like he showed up to her house to propose to her in front of her minor children, things that are, and also he left tons of voicemails, she says, and then I guess edited them all together and made a song out of the number of voicemails he had left for her. Really, really allegedly strange, bizarre behavior that arguably could weigh in favor of a longer period of time on probation. In any event, listen to this. Here we go. Representatives from the DA's office made fraudulent representations in court in favor of Monson. I know that you guys are, you can't believe that Fani Willis's office would be accused of making any kinds of fraudulent representations in court. Can you? I mean, that's just silly. I mean, who would think that the DA's office in Fulton County would make a fraudulent representation to any court? All right. Okay, back to the allegations. I just can't believe it. Fraudulent representations by DA. Anyway, due to DA Willis's bias towards Mr. Arrington, plaintiff Mainor has experienced disparate treatment under the law as a victim. Mainor was forced, she says, to notify the U.S. Attorney's Office on violence against women due to the DA's office failure to properly prosecute Monson's case at its inception. Plaintiff filed a bar complaint with the State Bar of Georgia, alleging defendant Commissioner Arrington used his elected position to sway deals as a criminal defense attorney. And on October 24th, 2020, Mainor filed an ethics complaint against Commissioner Arrington, alleging that he had violated several ethics rules during the adjudication of the state's case against Monson. See paragraph 69, where we're about to get to it. Mainor, it says, had 6 different assistant DAs on her case. The last one who took the plea was ADA Yolanda Mack. According to the Fulton County Deputy District Attorney Jill Hollander, the, quote, bouncing around of plaintiff Mainor's case was unusual. and the DA's office and DA Willis favored defendant Commissioner Arrington and Monson in the criminal proceedings, although Mainor was the named victim. Going on to say Willis was deliberately indifferent to Mainor's needs and violated her rights. Now, here we get into the ethics board complaint. And you remember, I said, if you go and look on Google, you can find news articles where Arrington is trying to take action, and he's not been successful because he didn't have the votes, but he's trying to essentially disband or otherwise get rid of the Fulton County Ethics Board. So there's a complaint with the ethics board. Mainor made several allegations against the commissioner stemming from the improper use of his political office for financial gain. It says the board failed to follow procedure while adjudicating the ethics complaint. The board refused, listen to this, guys, the board refused to hear the jail calls between Arrington and Monson. Refused to hear the jail calls. And listen, they say that they cited attorney-client privilege was the reason that they refused to listen to the jail calls. These were calls that were released to the publicly, apparently. And by the way, there is no, as I said earlier, there is no attorney-client privilege on a recorded line from the jail. So if you say that you're not going to listen to the jail calls and you cite that as the reason, then you're citing bullshit because it doesn't apply. In November 2021, Monson was released from jail and immediately began stalking plaintiff Mainor again. As a condition of his probation, Monson was ordered to have no contact, directly or indirectly. He began showing up to events hosted by plaintiff, her friends, and her neighbors. She says that she told the DA's office of this incident, and neither ADA Mack nor District Attorney Fani Willis took any action against Monson for continuing to contact the victim of this stalking, which would have been a probation violation and should have resulted in another charge, but I'm going to get to that. It says in December of 21, he attempted to enter the Coverdale Legislative Office building. That's where the legislature meets. It's down by the Georgia Capitol. That's where the plaintiff works when she's working as a state representative. Capitol Police stopped him from entering because he was on the do not enter list. But he said that he was there because he says the state campaign ethics office had instructed him to come in person to testify. But chief counsel to the ethics office said that he was not contacted and instructed to testify. Fast forward to a police investigation where the Capitol Police got involved, and investigator Hill concluded that Monson had violated the TPO or the TRO by entering the legislative office. He was prepared to pursue charges against Monson due to this incident. However, the Fulton DA's office, she says, refused to prosecute Monson's violation, therefore making an arrest warrant futile. Specifically, according to this lawsuit, Assistant DA Mack states that, quote, it doesn't appear that Monson's intentions were to violate the order, but to simply give testimony on his ethics complaint against you. He didn't have any contact with you directly or indirectly. But we heard from the state ethics office, and they said he was not there to testify. So I wonder why the DA's office would believe that to be the case and not take any action. All right. So before we get into the next piece of this, I want to come back over. We have 1,256 people in here, guys. Thank you so much for all of you for being here. Hit that like button for me. Please hit that like button because that's going to help the algorithm know that people like this channel, like what we're doing here, and it will certainly help this channel grow. Thank you for all of the super chats. Thank you for the memberships. And if you like this content, please feel free to hit the links in the description for ways to support the channel. Thank you so much. I see that we got a lot of questions in here. Can judges be questioned for passing the buck in an obvious case of wrong? Well, you can question judges. Of course, we do that a lot. But, at the end of the day, judges oftentimes have great discretion in how they do things. So oftentimes all you can do is ask the question, unfortunately. Coco, thank you, Coco. And thank you, Chat Boss Megan, for corralling everyone and making sure that you maintain law and order in this chat this afternoon. Thank you very much. All right. Here we go. Let's get back into it because Fani Willis, guys, Fani is accused of a RICO violation. Check this out. All right. The third claim for relief is racketeer influence and corrupt organization practices in violation of OCGA 16-414. It says, now that's a criminal statute, as we know, but there's also a civil cause of action. It says it's against defendant Arrington in his personal and his professional capacity, Willis in her personal and official capacities, and the Fulton County Ethics Board. They go on to say that it's unlawful for any person through a pattern of racketeering activity or proceeds derived thereof to acquire, maintain directly interest. So on, it's the same language that's in the Trump racketeering case, guys. You can look at it yourself. I won't read all of it together, but it says that basically if people endeavor together to violate any of the provisions of subsection A or B of this code section or commit any overt act to the effect of the object of the endeavor, then they violated RICO. The next allegations are just jaw-dropping. Defendant Commissioner Arrington tampered with evidence by speaking to DA Willis about the case before she was sworn in. Arrington commits bribery, she says, when he releases money to the DA's office in exchange for preferential treatment when he is working as a criminal defense attorney. I can't get my head wrapped around this one because you've got the man serving as a county commissioner that's in charge. They're in charge of the purse strings, but at the same time, so Willis goes to the board of commissioners asking for money, and then the next day, I guess the commissioner goes to the DA asking for a good plea deal when he's got a different hat on. So you see how that can at least give maybe an appearance of perhaps something that's a conflict of interest. It says that Willis engaged in a pattern of racketeering behavior by bribery in violation of Georgia Code 1610-2 and obstruction of justice. DA Willis engaged in bribery when she gave Commissioner Arrington and Monson, his client, preferential treatment under the law. Bribery, man. So this is the first step, guys. This is the complaint. The next thing that has to happen is the parties have to file an answer, and they generally will deny everything, say that, these things aren't true. And then you got the pretrial discovery process, and that's where you get depositions and you get people forced to come testify under oath. And wouldn't you like to be a fly on the wall when Fani Willis is deposed about allegations of bribery and violating the racketeering law? I would pay money. I would buy a ticket to that event. By the way, speaking of events, tomorrow at 10 o'clock in the morning, the Georgia Senate, for those of you who have been following this, the Georgia Senate, now the legislature in Georgia is not in session, but the Georgia Senate's going to have a committee in session tomorrow. It's going to be the same committee that Ashley Merchant testified before several months ago. And what I'm told, I've got it on pretty good authority here, that let's see here. Let me look at my pretty good authority. That tomorrow at 10 o'clock in the morning, you're going to have the chief financial officer for Fulton County, as well as the chairman of the county commission by the name of Rob Pitts, testifying as witnesses. So I found that to be, quite frankly, very, very interesting, that you're going to have sort of an off-season or outside of session committee. It's called the Senate Committee on Investigations or something like that, but it's the one that's looking into Willis and how her office has been doing business. So I wonder if some of these things are going to be brought up tomorrow. I wonder if some of these questions about the financing of the DA's office, I wonder if any of these allegations might possibly, maybe, perhaps could come up. So we'll also have to be watching to see. Yes, people are asking, it should be live streamed. That's my understanding. It was live streamed last time. It should be live streamed, not televised, but you can find it online. I go to this, I'll post it on X when I get around to it later, but there's on the Georgia State Senate has, its own website, and there's links to to the things that are going on. So you should all be able to see it. So yes, I will try to find, if I can, Sea Travel, I will try to find a link and I will try to post it. All right. So thank you all very much for being here. I'm happy to answer any questions. Deborah Carver, again, I haven't screened these, so I'm just pulling them up. By the way, normally Megan is able to star, and I can see these comments, they're starred, so I can look at things that she's picked. But for some reason, I'm not seeing the option to look at any starred comments. So I'm not able to see, it's not pointing out to me any super chats, things like that. And honestly, I've been in another screen, so I don't know, but thank you all for any super chats. Thank you for the memberships. Thank you for joining. Thank you for supporting this channel. It really helps a lot. Deborah says that she was one of the first subs, thanks to Megan Kelly. And Megan is a great, look, she's just so fun. It's a fun show to do. I'm really glad that we connected, and I look forward to, we're talking now about the next time we might be able to do an appearance with Megan Kelly on her show. Sea Travel again. Love how I call bullshit. Well, I mean, look, if it fits, it fits. If it's bullshit, it's bullshit. Another visit of Fulton corruption at the top. Look, I mean, again, this is just the starting place of this lawsuit. This is one that I'm going to be keeping an eye on. I'm going to look, whether it's successful or not, I think that it's very brave of Mainor to go ahead and file this lawsuit, to make these allegations. It's quite something. I want to share with you. Let's see if I can share. All right. This is mishandling.com. You can go and read about her. You can read about what she's doing as a state representative and all sorts of stuff. You can even drop her a line. You can see, by the way, her district is right sort of in the heart of Atlanta. It goes from the Midtown through the heart of downtown down to Southwest Atlanta up towards the Northeast. It's a large chunk of the city of Atlanta, of course, Fulton County in that. So it's very interesting that that is her area, but she's, I guess maybe it's because she's a Republican now. Maybe there's some of that partisan animosity going on, but in any event, that's her website. Go check it out. Thank you, Deborah. I just saw a super sticker. Again, these things are not being starred for some reason. I don't know, but thank you, Deborah. Thank you to Juanel and all the other new members. We have 1,100 people in here. Please, if you haven't done it, guys, hit that like button for me. That really will go a long way towards helping me grow this channel. Grammy is very interested about Willis being sued for RICO. And I was interested in this lawsuit when I saw it, but then when I didn't realize that there was a RICO charge in there until I dove into it. So I literally changed the title of this live stream here on the web from her just being sued, but to her being sued for RICO, because I thought it was very compelling myself. Yep. So there you go. Hit that like button. Guys, I've been here an hour. I hope I haven't bored you to death just reading this complaint, but I thought, and by the way, you should check it out. I'll see if there's a way I can possibly, thank you for that super sticker, Janelle. If there's a way I can perhaps post a link to it, I'll try to do that. It's a good read. It's an interesting read. And again, I have it on pretty good authority that there are going to be some amendments perhaps to that complaint. I don't think it's going to necessarily change, at least the factual allegations may not change all that much, but if it is, we'll of course get that out to you as well. But you can just add this to the list of things that we're following regarding Fulton County, the powers that be, and certainly with the Fulton District Attorney's Office. And by the way, I've got one more day, because I had predicted that by tomorrow, by Friday, the 3rd of May, I had predicted that we would have a ruling by the Georgia Court of Appeals on whether or not, they were going to accept the appeal on the disqualification issue. I certainly hope that we get a ruling by tomorrow, because I promised a radio host, Mark Aram here in Atlanta, I told him I would go in studio and I would eat my hat live on his radio show if I was wrong about that prediction. So sounds like I better get ready to eat my hat, because the time is running short. Hopefully I will get saved by the Court of Appeals in the next 24 hours. But in any event, we'll get a ruling here very soon. They have a very limited time window to do it. So we'll certainly be, and as soon as that happens, you can count on another live stream very, very quickly, because we're going to discuss their ruling, whether it's to take the appeal or to not take the appeal. Remember, if they take it, then argument is going to be later this summer, and it will be with a different panel of the Court of Appeals, and it's going to take 2 judges out of a panel of 3 to reverse Judge McAfee. All right. So, yeah, I probably ought to get a hat that has some flavor to it. Might make it a little bit easier to take down. But anyway, guys, thanks again for being here. That's all I've got for you for today. But before you go, remember, this is Fulton County.
Man, can I get the water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lies.
Yes, you may. We're gonna take a break. Hang in there.
Thanks, guys. We'll see you next time here inside the law.